Hello. Good morning and welcome to examining the case of Supreme Court v. Ethics. I'm Brendan Quinn, Senior Communications Manager for Campaign Finance and Ethics here at Campaign Legal Center. Thank you all for joining us. CLC is a national nonpartisan nonprofit organization that works to advance democracy through law at the federal, state, and local levels. We fight for every American's right to participate in the democratic process. We believe our democracy should be transparent, accountable, and inclusive. Justices of the United States Supreme Court are appointed for life, but strong and clear guidelines do not exist for them on the ethics front. The result is a federal judiciary that has accumulated a significant amount of scrutiny and mounting distrust. As the Supreme Court rules on cases impacting democracy, civil rights, and everyday life, voters have a right to know that the justices are delivering these opinions are acting on public good and not to further the agenda of a financial benefactor or a political ally. They need to create a reliable ethics structure for the Supreme Court, and that is clear and that is urgent. Such a system must not only provide clarity to the public and hold justices accountable when rules are violated, but must also provide clear guidelines for the justices themselves to follow. As things stand today, attempts to tackle corruption and its appearance across the federal government are hindered while the Supreme Court's increasingly brazen disregard for ethics remains at the forefront of the national conversation. Now, I will turn things over to our moderator for today, Joe Doyle, for federal lobbying on all of CLC's democracy issues, including voting rights and redistricting, campaign finance, ethics, and combating election sabotage. Prior to joining CLC, Joe spent more than 35 years as a lobbyist on Capitol Hill, fighting for equality and rights for women, of the LGBTQ community, and of labor and progressive movements.
Thank you, Brendan. Before we start our discussion, I would like to go over a few housekeeping items. During the conversation, please use the comment section on Facebook or YouTube to submit your questions for members of the panel. At the end of the panel, we will start the question and answer section. We will do our best to get each question, but in the interest of time, we may not be able to answer every one. If we're not able to answer your question today, and you are a member of the press, please email your questions to media@campaignlegalcenter.org. If you're a member of the public, please email info, I-N-F-O, at campaignlegalcenter.org. Now I would like to introduce today's panel. Kedrick Payne is Vice President, General Counsel, and Senior Director for Ethics at Campaign Legal Center. Kedrick specializes in government ethics, lobbying law, and election law. Prior to joining CLC, he enforced legislative branch ethics laws and standards of conduct as Deputy Chief Counsel of the Office of Congressional Ethics, where he was one of the office's first investigators. Next, we have Danielle Caputo, Legal Counsel for Ethics at Campaign Legal Center. Danielle works on the ethics team, holding elected officials accountable for ethics violations and proposing stronger ethics laws and rules for every level of government. Prior to joining CLC, Danielle worked as the Legislative and Programs Counsel at Issue 1, where she advocated for ethics and money in politics reform and the Senate Judiciary Committee. Also joining us is Robert Barnes, a reporter for the Washington Post. Robert has been a Washington Post reporter and editor since 1987. He joined the paper to cover politics and has served in various editing positions, including Metropolitan Editor and National Political Editor. He has covered the Supreme Court since 2006. And finally, Richard Painter, a professor of law at the University of Minnesota and former White House chief ethics lawyer. Richard was associate counsel to President George W. Bush in the White House counsel's office, serving as the chief ethics lawyer for the president, White House, employees, and senior nominees to Senate-confirmed positions in the executive branch. Thank you to the members of the panel for joining us today. So to begin, we've been hearing a lot about Supreme Court ethics this year, especially as a number of scandals involving gifts of free travel, lagging disclosure, and other questionable practices have come to light. What are we talking about when we discuss ethics at the Supreme Court, and how concerned should the public be on this issue?
I mean, I'll jump in here and just say that what we're talking about is a glaring problem at the Supreme Court where the ethics standards there lag in comparison to the other two branches of government. And the public should be very concerned because this is a problem that's not going away. And it's historic at this point. Never before have we seen in modern history this many justices embroiled in ethics scandals where there doesn't seem to be any type of resolution. And I'll say there's really two parts to the problem. One is with the ethics rules that are in place not being enforced. So there are financial disclosure rules that apply to the justices, as well as recusal rules. However, we are seeing scandal after scandal where it looks as though there are clear violations of these rules, but there's no consequence for the justices. And then the second category are those ethics scandals that are involving behavior that you would think there would be a rule that would exist, but there's nothing in place. So, for example, there is an allegation that a justice used her office staff to help promote her book and to get more sales. Well, in the executive branch and in the legislative branch, there are clear rules about how you use staff and how they cannot be used for your own personal financial gain. But the Supreme Court, that's not the case. So all in all, we're dealing with a problem that is something that the public really should pay attention to, and the Supreme Court should prioritize with coming up with a resolution. And if they can't, then that's when Congress needs to step in.
Would anybody else like to add anything? Well, to dive in a little bit deeper on what Kendrick just talked about, what role are the current ethics rules governing the Supreme Court, or as Kendrick has pointed out, a lack thereof, playing here? Are different justices interpreting the rules differently?
Well, I don't know if I would say that they're interpreting them differently, but the court is often described as 9 law firms, under one umbrella, where justices make many decisions for themselves, especially on recusal. And they are lifetime appointments. The Chief Justice has a little more power than the other justices in certain areas, but he's not their boss. No one is the boss of each other on the court. And so we have seen, as a result of some of these news stories that have come out and the allegations, that the court responds very differently. There were questions about trips, for instance, involving Justice Thomas and Justice Alito. Justice Thomas put out a statement saying he thought that this fell under an exemption for personal hospitality, which was he was taking a trip from a friend. Justice Alito went to the Wall Street Journal and wrote an op-ed that sort of defended himself before ProPublica's story about this even came out, with questions about the justices appearing at colleges and things that might be seen as fundraisers for those colleges. The court did interact more with the Associated Press reporters who were investigating this, put out more of a statement. Justice Sotomayor put out a statement about her book, the sales of her books. And so I think we have seen them all deal with it in various ways. And some have not commented at all about stories that have been written.
So clearly the Supreme Court has existed a long time without any clear code of ethics. And the justices' scandals have been going on for years in the making. Why is now the time to put pressure on the Supreme Court to adopt an ethics structure?
I think one thing that's really put a lot of pressure is since April, we've had 3 scandals involving the Supreme Court, which is basically a scandal a month. And I think that's really made clear how pervasive these ethics problems are in the Supreme Court. Even as a lot of the ethical conduct that did occur that we are learning about happened, 20 years prior, or has continued to happen over the last 20 years. We've seen just a wide variety of different kinds of scandals, as you mentioned, Joe, gifts of free travel, as well as disclosure problems or questionable practices involving staff on selling books and things of that nature. But most concerningly, there's no clear way that the court handles these issues. As Robert said, all the justices have interpreted the rules and responded to them differently. And there's no really clear course of action for what justices should or should not do in a lot of these circumstances. And public trust in both the Supreme Court and the government generally is steadily declining, I think, with every scandal that comes out, which is understandable. People see all of this unethical behavior. They see that there's no recourse, and they start to believe that the deck is stacked against them and their specific problems in favor of millionaires who are able to provide trips to justices, or justices are able to make money off of certain things. And that makes sense, that the public would feel like, okay, well, they can buy this access basically to justices. And I, as an individual, cannot. So I think that that's what's really made this the time to put pressure on the Supreme Court. It's become really clear that there's a problem.
So with that and moving forward, obviously both the other branches of government already have existing structures in place. Are there any aspects from either the legislative or executive branches' ethics structures that the Supreme Court could model after, or that would be better for them to follow?
Let me emphasize that the existing law applies to the Supreme Court. And it's quite clear under the Ethics in Government Act of 1978 that financial transactions and gifts have to be reported by all three branches of government. And that applies to the justices of the Supreme Court. The Chief Justice can say all he wants that they're voluntarily complying with the Ethics in Government Act of 1978, and perhaps he voluntarily complies with the speed limit when he's driving home. I don't think that's the way Congress sees it, and that's not the law. That is binding, the Ethics in Government Act of 1978, and it requires disclosure. And it's somewhat very similar in the executive branch. And I gave the ethics lectures to the White House staff, and I talked with incoming cabinet members, presidential appointees, Senate confirmed about the rules on travel. And first, there's a gift rule, another statute that also applies to the justices. You can't take a gift from someone who could be affected by your official duties, such as a free plane trip. Unless they're a personal friend, and then there's a personal friend exception, and then you'd recuse from any matter involving that person. But even if they're a personal friend, you have to disclose it. The plane trips, the yacht trips, that's transportation. It has to be disclosed. There's no carve out for personal hospitality from the disclosure rules for a trip on a private plane or a trip on a yacht. I made that really clear to the White House staff. I prepared Justice Alito and Chief Justice Roberts for their confirmation hearings on the ethics side. We certainly look for them going on free junkets like that and the kind of thing they would have gotten all sorts of heat for in the Senate confirmation hearing. And they passed their ethics review with flying colors retrospectively, looking back. But the problem is that both Justice Alito and Justice Thomas have a construction of the Ethics in Government Act disclosure rules that is just flat out not true. So they violate existing law. We've got law in place on this. They're just not following it. Recusal, 28 United States Code 455. They have to recuse, and that applies to justices too, in any case in which their impartiality might reasonably be questioned. Well, it seems to me that if your spouse is an insurrectionist or giving aid or comfort to insurrectionists, maybe you ought to recuse from insurrection cases. For example, Trump versus Thompson, where the January 6th committee subpoenaed documents, White House documents, that may very well have included text messages between Mark Meadows, the chief of staff, President Trump, and Ginny Thomas. Well, Justice Thomas needed to recuse from that. That's a slam dunk 28 U.S.C. 455 recusal requirement, and he just blew it off, and he was the only justice who said that he would grant Donald Trump, the former president's, a motion to stay the January 6th committee subpoena. Absolutely unacceptable, clear violation. So we've got the laws. They're just not following the laws.
Would anyone like to add anything to Richard's comments?
I disagree to Richard. I'm sorry, Robert, but I would just say that Richard's right that we have existing laws that apply to most of all the scandals that we're seeing. And then in the cases where there aren't any necessary clear rules that apply to the Supreme Court, there is the example that's provided by the executive branch and the legislative branch on what to do. One is dealing with the use of staff, but also with how to handle recusals. There are better ways to handle recusals that we have seen in the executive branch, where you have an agency ethics official who is there to determine where there are potential conflicts of interest and advise on when recusal is necessary, as opposed to simply leaving it to the official to decide without any advice where that could be a potential conflict.
Yeah, I would say, that the justice's response to that would be, we have to make our own recusal decisions that the Supreme Court, you hear this a lot from the Supreme Court. It's different from every other court. That is, that if a justice recuses, there is no one that could step in their place to hear the case. It will leave them with an even number of justices. In a close case, that would mean that the court couldn't render an opinion. That's not the case in lower courts, of course, where if someone's recused, another judge can fill in for them. Now, there's ways around that, certainly. But, the court's view has always been that its members should try hard not to recuse from cases. I think Richard has brought up the one that seems the most glaring most recently, in which Justice Thomas was acting in a case about the January 6th committee when indeed his wife was called before the January 6th committee.
Yeah, and I think that you're exactly right, where that would be the justice's response would be as different. And I think they should then disclose that. So if there's a case where they think they have a conflict, yet they think their duty to the country is to serve on that panel because of the implications if they were not on that case, then put that in a explanation for why the justice decides not to recuse, and then have it all be disclosed. Because clearly at the end of the day, there's no mechanism to force a justice to recuse. So therefore, disclosure is the only remedy that can be used to at least inform the public on the rationale behind the justice's decision to not recuse.
Mm-hmm.
You're absolutely right. Trump versus Thompson was not even a close case. You had 8 justices denying the petition of the former president to stay the subpoena, and only one justice saying he would grant the stay. And that was Justice Thomas. His wife's emails may have been in the subpoena documents. So it's amazing that he would do that, and that the other members of the court would tolerate that instead of saying you absolutely need to recuse from this case. And there was another one too later in 2022. I think it was decided on the shadow docket involving a subpoena out in Arizona of some documents from the Republican Party out in Arizona. And Jenny Thomas had been very much involved in the attempt to alter the electoral slate in Arizona. And he got involved in that one too. Basically, they're ignoring the rules and not calling each other out.
And the recusal issue is slightly different for the other branches. Danielle, can you go into a little bit how it works if a member of Congress accepted luxury trips or used their official power to boost sales on their books, on how that situation would be handled in the legislative branch?
Sure, absolutely. So if a member of Congress were to want to take a luxury trip that was paid for by a close friend in a similar vein to Justice Thomas, they would have to call their ethics committee, their respective ethics committee, and seek approval for that. If they do receive approval to take that trip, then they would have to publicly disclose the trip as well as who paid for it. And in the case of, the book sales, if a member of Congress used their official position or had a member of their congressional staff boost the sales of their books in a similar way to Justice Sotomayor, they would be investigated by their ethics committee. That's a clear violation of ethics rules in Congress that prohibit members of Congress from using their staff or using their own position for personal financial gain. Depending on how that investigation went, member could face a number of different sanctions, which could include at the most serious level expulsion, but could also include censure, reprimand, or even a fine.
So clearly there's a lot of ground to cover in implementing an ethics structure at the Supreme Court. We've talked about recusal, we've talked about gifts that will promote accountability and transparency. Can you all talk about what solutions are available that will not only provide clarity to the public, but also ensure the justices have clear guidelines to follow?
Well, I would say that one issue is that the court has been very slow in being transparent on a lot of these things. When we get the financial disclosures, for instance, in which they are supposed to be talking about and disclosing these trips or gifts that they have received, they're very late. We just received in June 23 their reports for the year of 2022. And so by the time you see some of these things, it is very late in the process. It used to be that the court, that to get even copies of these financial disclosures, you would have to apply for them and then go down to the courts and actually get physical copies of them rather than them being posted on a website. That's changed a little bit, but the court has been really slow in trying to sort of bring itself into the modern era with these disclosures. And I think it's right that in some cases it is very clear what should be disclosed. I think in some cases it is not terribly clear, but neither Congress nor the court itself has been very good at coming up with proposals that would make them clear.
So let's talk a little bit more about what should be disclosed and what shouldn't be disclosed. Does anybody else want to speak to that?
Well, I guess I'll just say that the disclosure law as it exists is very comprehensive on what should be disclosed. I mean, the public needs to know what are the justices' assets, their liabilities, their income, gifts they receive. And if that information is made public, then you have what you need to determine potential conflicts of interest. The problem that comes up, and one of the solutions, going back to your original question, is that you need more enforcement of those existing rules. So one solution would be just enforcing the rules that already exist with the enforcement mechanisms that already exist. And what I have in mind is the judicial conference. The judicial conference is the body created to deal with allegations that a justice has not disclosed what they're supposed to disclose. And so far, we've not seen any action taken by them to truly hold anyone accountable. They did take action earlier this year to clarify rules that were clear to other branches of government, but to clarify for the justices what the personal hospitality exemption really means. But if they could also take the responsibility serious to hold a justice accountable for willfully violating the disclosure rules, then that can be a solution to make more justices take it seriously and more lower court judges take it seriously.
I have just completed a law review article I posted on SSRN urging that there be appointment of both an ethics lawyer and an inspector general in the U.S. Supreme Court. And this is not a new idea. Senator Grassley in 2015 introduced a bill to have an inspector general for the entire judicial branch, including the U.S. Supreme Court. And I've spelled out in this law review article why that's a good idea and why I believe it will work. Inspectors general in the executive branch work within the agency, but are independent of the agency leadership. They are appointed by the president, but confirmed by the Senate, can be removed by the president, but the president has to give Congress 30 days notice as to the reasons for the removal of the Inspector General. And I believe that Inspector General in the U.S. Supreme Court, who is appointed with the consent, hopefully, of all the justices, but at least a majority, and then confirmed by the Senate, would be a very effective person to have on board. And the Inspector General could oversee ethics in the entire judicial branch, investigations of ethics violations. Now, initially, of course, I think that the Judicial Conference would be very helpful. They've been very helpful for the lower courts and ought to play a more robust role for the U.S. Supreme Court. But at the end of the day, the Inspector General, I think, is necessary, in part because an Inspector General, once they've investigated and reached a conclusion, if there is a conclusion there's an ethics violation, would report to Congress, as do Inspectors General in the executive branch. Now, the Inspector General shouldn't be going through the justices' draft opinions and getting into their deliberations in cases unless there's a bribery situation where a case clearly was influenced by corruption. But a lot of these matters can be investigated and a report drafted by an Inspector General sent to Congress where there's no disclosure of any of the confidences of the court. And I think that's a very necessary measure. Senator Grassley's bill was should have passed in 2015. It, of course, got buried in committee. And I've urged that Senator Grassley reintroduce the bill. I don't think he will, because now it's become such a political issue that Republicans want to deny there's any problem at all. And it's become partisan, which is unfortunate. So maybe Senator Whitehouse just reintroduces the bill, and I hope Senator Grassley would vote for his own bill and put Inspector General in there.
I think Richard has really hit on something that is affecting what's going on right now, is that there are all these concerns, and there is very little agreement in Congress at all. It has really become a partisan issue about whether or not the court should have its own ethics policy, who should implement it. It's conservatives and Republicans see these stories and this movement as a way to try to delegitimize a court that has become more conservative. And they say it's all about disagreeing with the court's decisions, not really about ethics concerns. And so I think, we've already seen that it's very hard for the court itself to come up with an ethics code. And I think we're now seeing in Congress that it's turned into just another partisan issue.
Which is interesting, because Senator Grassley, when he introduced the bill in 2015, I believe that's the year the Supreme Court legalized same-sex marriage across the country. The conservatives were upset at the court. And there was also talk of Justice Ginsburg and some of the more liberal justices perhaps being a little fast and loose with the free travel and the rest of it. And so that it was a partisan issue for him then. And now they just switched playbooks. And I believe that Justice Sotomayor had been caught on Harlan Crow's airplane. We'd have the Republicans up in arms. And that's not the way we ought to be dealing with the Supreme Court ethics. It's not a partisan issue.
Yeah, I agree. It's definitely not a partisan issue. And the hope is that because this issue is not going away and because there'll be more information coming out, that there will be no way for the lawmakers to just hold on to that argument, because there will be no way to avoid it. One thing that I have in mind that's going to happen, it will be the disclosure of Justice Alito and the disclosure from Justice Thomas of their trips and other gifts that they received last year. What happened just a few months ago is that Justice Alito and Thomas tried to describe, they didn't quite understand what the rules were. And Richard, you touched on this, but now that they know what the rules are, they got an extension on their disclosures that were due in May to August. And the expectation is, now that they know that how the rule is interpreted, all of the trips they took last year or gifts they received, presumably they did, will now need to be disclosed. And they can either disclose those gifts, which will probably be shocking, or do some legal gymnastics to say how the law should be bended where it still doesn't apply to gifts they received, which is still going to cause a problem. So the partisan card can be used as for a while, but I don't know how long that's really going to last.
With that obstacle, before we move on to general questions, are there other solutions that you think are available to us right now?
Well,
Well,
I'd say,
I'm sorry, go ahead.
I was just going to say, I think most obviously the main solution, and we've kind of touched on this a little bit, is implementing a code of conduct for justices to follow. This code should outline the clear rules for handling conflicts of interest, and there should be clear and specific guidelines for recusal. As Kedrick mentioned earlier, at least a required explanation for why justices will or won't recuse. But having a code of conduct without coupling some sort of enforcement mechanism, either with Richard's idea of an inspector general or an individual or just another ethics office within the court tasked with enforcing the code of ethics, but also providing guidance and advice to justices, then we would kind of see a lot of solutions to the ethical issues that we've been facing currently.
Yeah, I was just going to mention, there was a lot of pressure on President Biden after he was elected to either look at expanding the Supreme Court or coming up with term limits for the Supreme Court. And he set up a commission that would look at all sorts of issues involving the court. But it didn't ask for, he didn't want recommendations on what to do. And so it's a very complete and full document that goes through all sorts of things about the Supreme Court, including ethics and arguments on one side for certain ways to do it, arguments against it. And it's just sort of disappeared. I mean, the president does not seem very interested in this subject. He has criticized the court's decisions, but he has not really criticized the court that much. He said it was not a normal court, but didn't really say anything beyond that. And so there is not a lot of push for this except coming from Democrats in Congress.
Yeah, the problem is I don't think President Biden has the votes in Congress, certainly to expand the court. And that's in many ways a separate issue from the ethics concerns. It's not going to help if we just put more justices on the court who aren't going to promise to adhere to the ethics rules. And of course, they promise in a confirmation hearing and then they don't do it when they get there. So the president's hands are tied if Congress doesn't want to proceed to address this problem. The commission that President Biden put together had some interesting ideas, but they equivocated on an awful lot. And it was a bit of a concern to me that you had the commission was top heavy with academics at some of the wealthiest schools in the country that send a lot of clerks to the Supreme Court. And of course, if you're writing recommendation letters for your students to the Supreme Court of the United States, you don't necessarily want to be complaining about the ethics of the court all the time. So there's some issues here that really need to be addressed in Congress. And Senator Whitehouse is being very serious about this, some of the members of the House, but we need the votes in Congress to get a reform package through and send it to the president's desk. There's nothing else the president can do without the support of Congress.
I will say too, the Supreme Court could also take the initiative to implement its own code of conduct and ethics enforcement. And so while it seems to be going to Congress because the Supreme Court has not expressed any sort of interest in that, that isn't to say that the Supreme Court couldn't, take up that initiative and do something to really show that this is not a partisan issue and that they, as the 9 members of the Supreme Court in an unelected position, lifetime appointment, care about, the ethics concerns that are plaguing them.
Yeah, we looked into this earlier this year, and 4 years ago, Justice Kagan said to a congressional committee that asked about this, that the Chief Justice was interested in the court coming up with its own code of conduct that was specific to the Supreme Court because of some of the questions that we have talked about here and some of the things that make the court unusual. Nothing has come of that. The court, as I say, because the justices are independent of each other, when they want to act in this area, they would like for it to be unanimous or close to unanimous. And, as far as we can tell, they're not getting any closer to agreement on this. There's also been a lot of turnover on the court in the last few years. And so justices are just settling in. But I think everyone would be happy if the court did it for itself and did something substantial. But I think it's very unclear if that's going to happen or not.
And Robert, to your point, I think I agree with that they are probably trying to see if they could get unanimous support for it within the court. And even Chief Justice Roberts said maybe a month or so ago at an event that they are weighing, he didn't say weighing options, but he made it seem as though there's some hope that they may try to address it. But what I think could be something that I don't want to see is that they actually do agree on something, but it has no teeth, that is actually a code of conduct in name alone. And they try to appease those who say you need a code of conduct, but the actual content and the impact of that code of conduct is meaningless, and leaves the public in the same place that it is now, with not knowing whether or not the justices are avoiding conflicts of interest and trying to uphold the trust of the public.
You all have done an amazing job of talking about the problems and the obstacles and some of the solutions and next steps. We have some questions coming in from the audience, and I'm going to start moving to those questions. From Madeline from Facebook, who asks, what is the recourse for cases SCOTUS decided when there is a clear conflict of interest?
You probably hear silence because it's not, there's no real recourse. Let's say if there's a justice who decided a case where there is a conflict of interest, either with one of the parties or in some other way, you clearly couldn't reverse the decision. And with any ethics issue we're talking about with the justices, they're not going to be removed from the court. You're not going to reverse any action the court takes. I think at most what you would expect is that there would either be pressure for that justice to resign, or the Congress could take that incident along with a lot more evidence to try to consider whether impeachment is in order. Both would be extraordinary steps.
Yeah, the irony is that lower court decisions where a judge fails to recuse in accordance with 28 United States Code 455, lower court decisions can be reversed by the Court of Appeals, and there have been some reversed by the United States Supreme Court. But if the United States Supreme Court has a conflict of interest and a justice sits on the case, even if that were the deciding vote, there would be no recourse. And that's why this is such a serious situation. Now, once again, that wasn't true in Trump versus Thompson because it was such a slam dunk. Donald Trump didn't have any standing to try and block a subpoena that Joe Biden was going to turn over the White House records. But there could be a case where there's a 5-4 and one of the 5 has an impermissible conflict of interest. Right now, we have no recourse at all.
Remember the justice who said the court is not final because it's infallible. It's infallible because it's final. Or do I have that the other way around? But basically, because the court makes the final decision, that is often it. Although, of course, in some cases, when the court makes a decision that Congress disagrees with, Congress can pass legislation that changes the outcome or changes the law.
Okay, we have a question from Carolyn Brown on YouTube, who asked you, who or what is going to set up the rules of ethics? From where will I get those rules?
Well, I guess to start, we discussed this a little bit, but the Supreme Court can set up their rules, their ethics rules, or Congress could pass rules for the Supreme Court to follow. And from where they get those rules, I think, you have two branches of government that already deal with a lot of the ethical questions and issues that we've seen presented to the court in the last few months. And the court could definitely get guidance and use those as a basis to inform how they're going to create those rules that would apply to them.
There was an interesting discussion in the Senate Judiciary Committee about this issue and whether or not Congress could pass an ethics code for the court, whether it could require that the ethics code, that the court create its own ethics code, or whether Congress didn't really have much to do in this area and that it was up to the court as a independent branch of government, a separate branch of government, to come up with its own ethics code. There wasn't a whole lot of agreement about that, as you might guess, because you know what happens when you get constitutional law professors together. No offense intended. But the Chief Justice has been extremely protective of the court's independence, and he didn't appear at that Judiciary Committee meeting because he said it was inappropriate, and sort of compared himself to the president, saying, you don't haul in the president testify before your committee. You can't really haul in the Chief Justice of the United States either. And so there is a real sense, I think, of independence from the court that would come into conflict if the Congress moves to come up with its own prescription for the courts.
Yeah, we have the same issue sometimes with the president, where the president thinks he can do anything he wants. And the Supreme Court has been pretty clear that that's not always the case. In Trump versus Vance, they made it very clear that the president must comply with a state court grand jury subpoena. United States versus Nixon, the president must comply with a subpoena from a special prosecutor. Clinton versus Jones, the president can be sued in a civil capacity. And we have checks and balances in our system. And yes, there needs to be some independence of Congress, some independence of presidency and the court. We have three separate branches, but they're not entirely independent of each other. There are checks and balances. And the Congress determines the number of justices, determines their pay, and a number of other matters concerning the court, and would, I think, clearly have the authority under the Constitution to pass an ethics code when they already have, as I said, with respect to disclosure, gifts, recusal for the justices. Now, they could go too far. I mean, if they change 28 United States Code 455 and say a Supreme Court justice can't participate in a case involving the president who appointed that justice, they could go too far, and then we could have a conversation about whether there's an unreasonable encroachment on the autonomy of the Supreme Court. But the Supreme Court itself, as I said, has never adhered to the view that any one of the three branches is entirely independent of the other two, at least when they rule with respect to the presidency and Congress. So I don't know what's so special about themselves, other than I guess they're ruling on themselves and have a conflict of interest right there.
So, Richard, our next question goes into that answer, but if you could go into a little more detail. So Woodrow Campbell on YouTube asks, is there anything the Senate Judiciary Committee could do to try to uncover unethical practices by lower court judges, like through subpoena power?
Because they can subpoena. I think they're going to be there's going to be review of those subpoenas by the U.S. Supreme Court, and there's going to have to be good reason for their subpoenas. They're going to have to be narrowly tailored to what Congress is trying to accomplish. Once again, the Supreme Court ruled on that, Trump versus Mazars, and actually ruled against Congress. They can't just subpoena all of the president's personal financial records unless they have a specific reason. If they had had an open impeachment hearing at the time on Donald Trump with respect to his personal finances, I think Trump versus Mazars would have gone the other way. But the point is that a subpoena, including a subpoena of the judicial branch, could be enforced if it's narrowly tailored toward a specific objective. If they start trying to subpoena drafts of opinions, we're going to subpoena all the drafts of the Dobbs opinion and that kind of business, they're going to get shut down, and they should get shut down. So ethics should not be confused with substantive decisions, unless, once again, there's evidence of bribery or something to change an opinion. We can have a conversation about that. But a sensible, narrowly crafted subpoena, whether it's at the lower court or I think of the Supreme Court of the United States, if it's narrowly crafted to deal with specific allegations of violations that ought to be enforced, I think the Congress should be able to subpoena all of Justice Thomas's travel records right now. I hear there may be some other billionaires out there who've been showing him around, and Congress needs to flush this out.
And as regards to lower court judges, obviously there have been cases where the Senate has investigated and impeached. The lower court judges have been impeached and removed from office for bribery, for other problems.
I think, too, it's also worth mentioning, not the Senate Judiciary Committee, but lower courts are bound by a code of conduct through the Judicial Conference, who also has subpoena power. So they would be probably dealt with through that mechanism first, before it would be dealt with through the Senate Judiciary Committee.
Any other comments on that one?
Everybody commented on what I was going to say, especially the part about the history of Congress impeaching lower court judges.
All right, so we have one last question before we move on to final thoughts. With the increased discourse of sensational reporting regarding ethical conduct on the Supreme Court that we've seen this year, do you think change is on the horizon? Have you, in your various positions, seen any change that we can grab onto?
Well, I guess I'll start. I have seen a slight change in the way some of the justices disclose and talk about things. We have seen, for instance, in some cases where they have recused, and the justices do recuse quite a bit. Individual justices. Some of the justices have started giving a little bit more of an explanation as to why they recuse, instead of just saying that they took no part in the discussion of that case. Justice Kagan, for instance, now adds sort of an addendum that it's because of past government service, and she was President Obama's Solicitor General, and so that would mean that she participated in that case at some point before she joined the court. That's a very common form of recusal for the judges who ascend to the Supreme Court. They've worked on these cases before that then come to the Supreme Court, and they recuse from that. I thought we saw a little more specificity in the financial disclosures that were filed in June, a little more detail on what they did. We talked about book sales, for instance, which is something, I should say, is something that Congress has exempted and said that the justices can make money on books that they write. While they're limited in outside income in other areas, they are not in regards to the books that they write and sell. We saw a little more detail from Justice Sotomayor about that, who has written several books since she's been on the court. And we also saw that Justice Kagan, for years, she had listed a rental income that she received on a property that was worth less than $50,000 in the District of Columbia. And the amount of money she got from it was quite small. And we were all starting to wonder exactly what is worth $50,000 in the District of Columbia that you could own and rent out. And it turns out it was a parking space at her building. And so in this latest disclosure, she spelled out that that's what she was talking about.
Yeah, I do think that there is hope that something's going to happen on the horizon, but it's in these little incremental steps, like Robert just described. One other thing to look at that will be a metric of change will be what happens in September when the Judicial Conference meets. The Judicial Conference will need to consider complaints that were filed against Justice Thomas that request the Judicial Conference to refer Justice Thomas to the Department of Justice to investigate whether he willfully violated the disclosure rules. This was done maybe 10 years or so ago, and the Judicial Conference didn't address it at all. There's so much pressure, as the question mentions, that comes from the media attention on the Judicial Conference this time. I think that it will be addressed, and they will have to have quite a detailed explanation to explain if they do not decide to refer Justice Thomas to the Department of Justice.
One thing I want to add is I think we do need to revisit the book sales issue. In the executive branch, an official is prohibited from earning royalties on a book that on the subject matter of their official duties. So if you want to write a book on something completely separate from your official duties, you could make money on royalties. But otherwise, no, that's ruled in the executive branch. And I think that ought to be the rule for the Supreme Court of the United States. There are too many conflicts of interest. You got big book advances. We've had some justices fail to recuse. I think Gorsuch and Justice Sotomayor failed to recuse from cases involving Random House, their publisher. The most serious problem is that they're making a lot of money in these book sales, and they sell to people, obviously, who like them, who agree with their ideology. And I think this is making the polarization of the court worse. If justices become heroes or heroines for the right or the left of the political spectrum, and then they're selling a lot of books, making money on that. When a case comes along where maybe a liberal justice thinks they should side with the conservatives or vice versa, you can't help worry that is going through their mind is, well, gee, this may make me unpopular with my base. And, a president should have a political base, a member of the Senate, a political base. But a Supreme Court justice should be able to change their mind and rule based on the Constitution and not be looking over their shoulder thinking, well, how's this going to affect my book sales? And they have been making millions of dollars on book sales, far more than they're making as the justices of the court. I think it's very, very unsavory. So I think Congress ought to think seriously about applying the executive branch rule on book royalties to the judges, to the judicial branch. I think we have a different rule because some of the judges were law professors and had these case books and treatises that we law professors write that are pretty boring and aren't going to be sold down in the corner bookstore. But that's not the kind of book they've been publishing over the past 20, 25 years out of the Supreme Court. And I think we need to revisit the book sales. I think it's a serious problem.
If I could add to that, it's interesting too. The two newest justices, Justice Barrett and Justice Ketanji Brown Jackson, both got book deals almost immediately upon joining the court.
Well, thank you all. Before we bring this to a close, I'd like to give our guests a chance to leave us with some final thoughts and predictions as to what in the ethics structure at the Supreme Court would look like and how we get there. Kedrick, why don't you start?
Yeah, I would say that I think the ethics structure, hopefully, is going to mirror the other two branches of government, because the court will see that the things that they say they are just voluntarily complying with should be binding codes of conduct and binding rules and regulations that have been coming out of the Judicial Conference on the acceptance of gifts. So I hope that they will follow the model that's been set up, especially when it comes to enforcing those rules. To have an internal body that could be an IG or it could be something else. IG will probably be the strongest, that enforces the rules, but also someone there that can give the advice needed so that you have consistent, clear, accurate advice that applies across justices, across the different errors within the court so that you can have integrity that is not simply ad hoc, but something that is actually rooted in core advice and core reasoning.
Richard, do you want to go next?
Well, I think the Inspector General is critically important. We have an executive branch, and it's helped a lot. And to have an independent Inspector General in the executive branch, President Trump fired a couple of them, but usually they don't get fired, and if they do, there's a congressional investigation. The ethics lawyer in the Supreme Court would be a very good idea, too. I performed that function in the White House for 2.5 years, advising the president and his staff and the cabinet members and the two nominees for the Supreme Court, Chief Justice Roberts and Justice Alito. And I went through all those rules about airplanes and free travel. And because, of course, we were worried about, gee, did they do anything on the Court of Appeals that Teddy Kennedy could use against them? But I guess some of that was all forgotten as soon as they got up to the court. So we need an ethics lawyer to go on up there and be there full time as well. I want to emphasize, we've got to convince the justices this is of the utmost importance. We've got state legislatures down in Alabama who want to defy the orders of the United States Supreme Court, who basically flipping the middle finger to the court. We had that problem in the 1950s and 60s with respect to court orders on desegregation. And the court is losing credibility. We've got a far left law professor up at Harvard Law School saying that President Biden should ignore the orders of the Supreme Court of the United States. So we've got the integrity of the court, the legitimacy of the court, the authority of the court is on the line. And I believe that the Chief Justice and the other justices need to focus on that, not whether they can take free trips on airplanes with billionaires when the court's not in session.
Thank you. Robert?
I think I'm going to leave the prescriptions for what they should do to you folks who are better qualified, and I'll go by my long-standing belief that I shouldn't tell the justices what to do, and they shouldn't tell me what to write.
Perfect. So Danielle, you have the last word.
Okay, well, I guess I'd like to conclude by saying that the court's inability to address these ethics issues is not new. Kedrick mentioned that, there was a letter written to the Judicial Conference 10 years ago about Justice Thomas. But I do think that, to answer also your previous question, the momentum is now there. The problems that are facing the Supreme Court are really reaching the public now, and the call for reform is too strong for the court to just straight up ignore it. And that goes the same for Congress. So I think we have to keep the momentum going. We have to continue to have important reporting done by people like Robert, and we need organizations to continue to review financial disclosure reports, to find issues as they arise in the Supreme Court, to make sure that people don't forget about this issue and that we put enough pressure on the Supreme Court or Congress to make something happen. To what Kedrick said, the solutions are relatively simple here. They have a guidebook through 2 other branches of government, as well as code of conduct for lower court judges that they can, use to instruct their own code of conduct. And I think that it's really critical for the public's trust in our democratic institutions that the highest court in our nation be held to, at least at the bare minimum, the same ethical standards that the legislative branch and the executive branch are held to.
Great, thank you. So as a reminder, if you have additional questions that weren't answered and you want more information, please email us at info@campaignlegalcenter.org. I want to thank the speakers for their time and for their wisdom and for joining us today. I hope that everybody enjoys the rest of their day. Thank you for joining us.
Thank you.
Thank you.
Thank you.